Good evening, everyone.
Good evening.
Yeah, good evening. How are you today?
I'm good. How are you?
So. Okay. Yeah. Actually, I have a long day today as well because I have lectures during the day as well. So a bit tired. However, yeah, we will continue with our class. Okay.
Well, weekend is coming. I hope you have a good rest.
Okay. Thank you. All right. So I just saw the screen that we are looking at last time. Okay, previously in the previous section, we were looking at guideline for revising draft contracts. Okay. All right. And I remember that we already looked at revising old text, is it? Let me see. Turn on the light, please. Okay, sorry. Sorry for a second. Okay. Okay. I think that we will stop at this page, right? Finish this already. Okay. Actually, I mentioned earlier, you should, even though in this material, they said that you should use active voice rather than passive voice. But in fact, in a contract, we often use passive voice. And the reason for using passive voice, as I mentioned earlier, is that because in a contract, we more focus on the action, okay, what the party have to perform, okay. So for that reason, we focus on the activities rather than the subject, all right, because the subject's already been clearly stated at the beginning. For example, Party A have the following rights and obligation, Party B have the following rights and obligation. However, in order to emphasize on the subject who need to perform a particular action or particular activities, and then we need to use active voice rather than passive voice. So it depends, okay? It depends on the situation. But if you want to emphasize on the subjects, and then you should use active voice. But if you want to emphasize on the activities, and then in that situation, you should use passive voice, Okay, there is no strict rules on using passive voice, even though passive voice are not subjected to use. Okay, all right. And remember that, as I mentioned earlier, you should actually keep the sentence short. Okay, and you should check that every sentence need to have a subject and a verb. Okay, and it can be an object, but the subjects and the verbs are must stated in the contracts. Okay, and as I mentioned earlier, keep sentences short. Okay, all right, because if you use long sentences and complicated structures, and it could make people too difficult to understand or follow. Of course, I understand, and I mentioned earlier in the previous sections, that for some provisions, you need to put it very, it needs to be a long sentence. The reasons is that because the subjects have to do certain activities. So you do not want to repeat so many times who have to do that, who have to do this. So in such a situation, you may put who have to do that at a leading sentence, okay? And then below you just list out the activities. It's okay. But for each of the activities, you need to use short sentences, okay? Or you use commas, semi-commas, etc. in order to break. And usually in contract, they will use 1E, 2E, 3Es, okay? They use different types of numbering in order to make the sentence separate from each other, phrases separate from each other. Stress need to be given in order for people to understand what are the activities that they need to do, that they need to perform. This must be very clear. It could not be mixed. It could not be vague or ambiguous, okay? So when you write a contract, make sure that every sentence that you put in a contract must have a clear meaning, okay? And as far as you can, do not make it be understood differently from different people, from different reader, depending on their level of understanding, etc. Of course, there are some types of contract which are very complicated, and also because this is a legal documents, people who have no legal knowledge may not understand. Like people who have legal knowledge will find it easier to understand, but put in the situations that people have a same knowledge of the fields. When they look at the language of the contract, they need to understand it similarly, okay? All right, if not the same, okay? It could be similar. Okay, you should keep subject and verb together. What does it mean? This means that you should not put the subject here and then you put some phrase in between the subject and the verb. Of course, sometimes you need to do so, okay? Because you need to have some adverbs or phrase to be used as adverbs or adjectives, okay? But remember that you should put it as long as you can. You put it together, the subject and the verb, okay? All right, just for a second, just wait for me for a second, okay? Okay, so you need to look at the first sentence here. Keep the subjects and verb together. A short interruption between a subject and its verb will not slow readers much, but a long one will interfere with the communication process. Okay, and you should keep pronounced verb together. Do not force the reader to keep too much in their mind. Okay, put verb earlier. Okay, put verbs early. Let reader know what sentence is going to do, what a sentence is going to do. Put main clauses early as well. Okay, you need to put, you know that when you write English, there is a story that you need to know that for English writing, for one paragraph, you should not mention two different things, two different topic sentence, topic in one sentence. Okay, you need to focus on, one thing. Okay, one obligation, for example. Okay, you should not put too many things into one paragraph. Okay, you should have a topic sentence for the paragraph, and if you have other ideas, you just put it as a supporting idea. You should not put so many matters into one paragraph. Okay, make the paragraph is clearly state about one thing. That is about how English should be written. Okay, that is when you write essays, etc. You have to follow that rules. When you write the contract, you need also bear in mind that for one paragraph, you should say about one thing. Okay? And also remember to look for grammatical parallelism, which means that you need to use the structures in parallel consistently. Okay? For the tense also, in one sentence, it is a prohibition in English writing that you use verbs in different tense. Okay, you should use at least, it must be present tense, or if it is past tense, one tense only. It can be past perfect or simple past tense, but you should not put in one sentence one verbs in present tense and the other verbs in past tense. Okay, so you should put it parallel. Okay, in parallel. Okay, all right. The heading needs to be also in parallel. Okay, you need to follow one style in one piece of writing, especially for legal writing. Okay, you keep one style. Okay, one style. All right. All right, I think that we need to do some exercise in order to be clearer about what you need to do. Just for a second. I will let you know what could be exercise. Okay, so now this is an exercise that you need to do in order to, just for a second, the exercise about how to make the sentence soft. How to make the sentence soft. I will let you know this. Second, try to put it here. This sentence is quite long. Look at this. How can we make it shorter? This is one long sentence. Anyone can put in the chat box how you make it shorter. So it means that you should break the sentence. Yeah. How can we make it into 3 sentences? Tiên ơi, Tiên share host cho cô để cô copy cái chat Tiên ơi. Thank you. I can't. What's wrong? I have a problem of copying. It seems that I have some problem with copies. Okay, thank you, Tiên. Okay. Okay, you can see on the screen. Okay. Đức Hebrech the sentence into three. Okay, the original, this one from Huang Ming, but I just want to put the original sentence here. I have a problem with copying. Maybe my computer have some problem. Okay, so the original sentences is this. Okay, this is the original one. It's one long sentence. You can see it has been determined that this is not a major amendment in the EU directives 12291 because this amendment will not result in an annual effect on economies of $100 million or more, or a significant increase in cost for consumer industries, the communities, member states, or local government agency. And Huang Ming have break them into, in fact, two sentences, right? Two sentences. One is that it had been determined that it is not a major amendment under EU directives 12291, and the reason is this amendment. So this means that you duplicate the term, this amendment will not. Maybe if you do this, I think that the reason, so if I just want to revise Huang Ming sentence a bit, it had been determined for not duplicate, this amendment will not result in, right? So you could say, you may not have to be say it had been determined that it is not a major amendment, because you can see that it's not necessary to say it had been determined. Okay, you can say that this is not a major amendment under EU directives 12291. The reasons are this. You may say this is because, or if you do not want to say that, it could say the amendment will not result in no okay, so you can make it like this. Okay, it's clearer, easier to understand. And Minh Đức did not break the sentence. He actually softened the sentence by summarize it, but maybe it did not actually appropriately reflects the original one. So you make, when you have to paraphrase something, when you want to make them softer, you need to break the sentence into softer sentences, and you should keep the original ideas, the original intention as much as you can. If you do something like Minh Đức and then it's become maybe not appropriately or correctly reflect the original one. Okay? Or for the first one, you may say something like this. Or the other way. Okay? Or you may put it like this. This is not a major amendment under EU directives 12291. Okay? This amendment will not result in an annual effect on the economy of $100 million or more, nor will it significantly increase in cost for consumer, industries, community, member state, or local government agencies. So that is the way how to make the sentence short. Okay? You should break a long sentence into short ones for reader to easier understand, especially when you wrap the contracts. Another example, I just want to show another example. I will give you another example to do, okay? Okay, could you please look at this sentence and how you make it shorter or easier to understand? how can you make the sentence shorter? Or how can you make it, you break it into different sentence, shorter sentences with different phrases if necessary, or if required to make it simpler, easier to understand.
Could you please, teacher, could you move this
Into the
sentence
chat box, yeah?
into chat box? Yes.
Yeah. Okay.
Thank
Okay.
you.
I will. Yep. I will move it to chat box. Yes. It's easier for you, right? Okay. Understand.
Yes.
Yep. Okay. Yeah. Anyone can make the sentence shorter? Break them into shorter sentences.
This one is really difficult.
So remember the rules that I told you. Remember to put the sentence like the subject and the verb together. And when you want to stress, okay, you should stress on the subject and the verbs. Go together with that subject. Adverbs or phrases used to support the main phrases should be put later. Anyone put your sentence on the chat box? Yeah, you can try. Yeah. And then please copy it, paste it in the files, because I have some problem with copy and paste from the internet or something. Okay, yeah, so let me see the one here. Yep. The last sentence, right? Minh Đức is still one sentence, even though you break them into different phrases using comma, but it's still one sentence. Can anyone break it into two sentences or more? And you should remember that you need to remain the meaning of the sentence, the original meaning of the sentence. Okay, when you restructure the sentence, when you paraphrase the sentence, you should keep the main or the original meaning. Okay, how about this sentence? Can you look at this sentence? What do you think? So you think you compare the two? Okay. So for the second one, we break it into two sentences. Okay. And then we put the main part. I'm sorry. Okay. You can see here that the main part of the sentence is that income generated from selling a residential house will not be taxed. Okay. If that residential house is the individual only or main residence, and the periods in which the tax will not be charged is that the periods when they have an ownership over that house, and the periods that that person, the certain periods after the time when that person is not used at a residential house. So we can see the paragraphs at revise underneath. You can see under section 202.1, you can say according to or under sections is okay, right? Income generated from selling a residential house will not be taxed if it had been the individual only or main resident. Okay, the first conditions is that if it has been that individual only or main residence, okay, throughout the periods of ownership. So it is the only, okay, or the main resident during the periods of ownership. So is the first conditions, okay, that it had been the individuals only or main resident, and it will not be taxed during throughout the periods of ownership. Okay, so continues throughout the period. So two conditions, okay. One is that it has been that individual only or main resident, only house, or it had been that person main resident, okay. So it means that if it is not that individual only house, it must be that individual main resident, okay. And the only house or main residence will be examined throughout the periods of ownership or throughout such periods, except for the last 36 months, okay. So it means that if in the last 36 months, that person can actually make the condition as stated above, like that person only resident or main resident, okay. The exception of 36-month periods apply to the periods during which the house was not used at the place of residence of the owner or used for lease or other alike purposes. Okay, so the last 30 months, okay, if in the last 30 months, if that person used the house not for the place of the resident or used for lease or other alike purposes, this is okay, okay. with the exception of 30-month periods apply, which means that the requirement that is that individual only resident or main resident have an exception, okay? Which means that within the last 36 months, that person may use that house for other purposes, all right? But it's okay if it's just only for 30 months, the latest 30 months, starting from the time on which the person sell the house, okay, calculate outward, okay? So that is difficult to understand, but in comparison between the first paragraph and the second paragraph, it may be easier for you to understand if you break them into shorter sentences, okay? It could be easier for you to understand. The first paragraph may be more difficult for you to understand, but the second one, even though it's still complicated, difficult, but the second one is easier for you to understand. Okay, is it clear, everyone?
Yes, it's clearer.
Okay, all right, good. So now we continue on defined terms. Okay, so why is it necessary for every contract to have a defined terms? Okay, so the first question is, when should you use defined terms? When you wrap the contracts? When you should use defined term? You can see that in contracts there will be a article and article, usually the first articles, definition and interpretation, or it can be put as an appendix to a contract about defined terms and interpretation. So may I ask, when is it necessary for you to have a defined term section in your contract?
I think it's when you know that you have to use that a lot of times, so you don't have to repeat it every time.
Right. Usually for long contract, okay, complicated contract with many terms and conditions, okay, usually for long contract, and when particular terms are used for more than one time, okay. If you in your contract you may use several terms more than once, but it's not necessary to have a defined terms if the number of such terms are not many, okay, are not many. And in such a situation, it may not necessary for you to have a separate defined term section or an appendix to a contract with the defined terms and interpretation. But if it is a complicated contract, and usually the terms, some terms are you repeat very frequently, right? And you need to have a defined term section. Okay, it can be an article in a contract, or it can be in an appendix, okay, appendix to a contract. So how do defined term work? Of course, one of your friends already mentioned that defined term work in the ways that reduce the length of the contracts, okay, reduce the repetition of terms in many provisions of contract, and more importantly, is actually more concrete, okay, because if you already make a defined term for a particular terms, usually for that term you will put it in a capitalized, okay, it's easy to recognize, and if people, when they look at those terms, shorten, most very shortened one, and then they can refer to the schedules of the defined terms or the articles that give defined terms, that provide defined terms, to check for the meaning, and it could be more accurate when you refer to that term, it has specific meaning and defined in a particular part of a contract. And you can see that in some transaction documents, For instance, if you borrow money from the bank, and usually you will have at least two contracts. The first one is the loan agreements or loan contracts, and the other ones is securities contract, that is a similar one. But sometimes for the financing documents, it could be a very complicated set of documents, especially for financing of projects, when you borrow money to finance the projects, and it could be so many documents need to be executed by the parties, and maybe it involves the parent company to give some guarantees, and the parent company actually mortgage properties to secure for the performances of the borrowers with other different entities. So they may be very complicated, and maybe one provision of one particular provision of agreement in the transaction document, they refer to other document in which the terms have been defined. So for complicated transaction, maybe you have to link all of the relevant agreements into one set of documents, and you need to check the connection among different transaction documents, and usually the defined terms are given in the main contract within the transaction documents. Okay, so it could be very necessary in the situation when the transactions is complicated. There are several agreements need to be entered into by the parties, and not only agreements, but also some other documents referred to by a document in a transaction document. So it could be very difficult. Okay. All right. So we will look at some advice when you need to define the term in the contract, when you need to wrap the defined terms. Oh, I think that I should also introduce to you about the some vocabulary just after we finish this using defined term. You can see some advice here for you when you wrap a defined terms. When should you use defined terms? As soon as you know, you will refer to the same concept more than once in the documents. But if you want to put it in a separate section or separate article or separate schedules or appendix, you need to ensure that you repeat them. So many terms are repeat. So you need to have a separate section to deal with defined terms. Okay, and the defined terms also necessary when it takes more than a few words to explain the concept. So in that case, you need to have defined sections in order to give you use a shorter phrase, okay, to explain something, and you do not have to repeat the long definitions when you refer to that terms again. And in that situation, you need to have a defined section in which those terms are defined. And when you use the defined terms, you should be make the terms in capitalized that stand for a long explanations of those terms. So the terms need to be relevant to the explanation. Do not use the terms with misleading, okay, with raise also some confused. You should not do so. So you try to use the shortened terms which can be understood in the ways that you explain those terms. Okay, do not use the short-term terms with have totally or very different meaning from the explanation. Try to do so. Okay. You can see about the second questions. How do defined terms work? External defined terms are unique to the external circumstances of this particular transaction. For example, names of the parties, location of real property, etc. They tie the document to the outside words and the larger transaction. External defined terms are especially useful when facts are subject to future developments and the exact detail of transactions are not yet known. They should all be defined early in the document. So it means that when you need to refer to some other external materials outside of the contract, you need to have a defined terms in order to link what you are discuss or what you are providing in this contract would have connection with something outside of the contract documents, but that also be developed or be changed or be revised during the time. For example, you may refer to a particular standards, for example, and you may say the standards that amended from time to time, for example. When you talk about a specific standards, you refer to a particular other documents which are not in fact part of the contract by putting inside of the contract, but by reference to that document becomes part of contracts as well. Okay, by using defined term. It is also an internal definition. Usually we use internal definitions, and that is refer to the concept internal to the particular documents. Okay, and yeah, it depends on the terms that you want to use. Some terms that you are defined because it's relating to other documents which are outside of the contract, and you just use the defined term to link your contract with some outside or external materials. But most of the case, more frequently, you use defined term to define something that provided for in the contract itself. Okay. The next question is, how can defined terms simplify transactional documents? They can assure that, the defined terms can assure that any particular lottery list will appear only once in the document, and that reserves simplicity, certainties, and consistencies. Okay, so you do not have to repeat the long phrases, and when you repeat long phrases in different places in the contract, and maybe you miss some words or you refer to different terms, etc., that may make misunderstanding or misleading. Okay. If properly structured, defined term can allow you to make a necessary change only one, right? Because when you want to redefine the term, you only have to fix the definition section. Okay, you do not have to go to every places in the contract to revise it. Okay, when you want to revise some terms or the meaning of some terms that already been defined in the defined definition section. Okay, and it could similar for you because you just only have to amend the definition, and you have to do so only once. Okay, and also defined term can help you to prevent a maze of cross references. So if you do not have a defined terms, and then when you need to refer to that particular terms, you need to refer to particular articles, or you need to refer to, or you need to repeat the long terms, or more frequently, you need to refer to other places when the long term, the phases were not defined many times. It makes it very complicated. If you use defined terms, cross-reference become simpler. Okay? And the last very important advice is that how should you create DeFi terms? And you should take a structured approach, setting up definitions and building block that work together. So one of my experience when I create a definition phase or definition article or definition schedules is that at the same time, I open two documents at the same time. One document is the main text of the contracts, and the other document is the provisions on definition or the schedules on definition. So I have that handy available one side, and when I wrap the contracts, the term and conditions of the contracts, and when I want to use the DeFi term, I can simply look at a DeFi term in a softer documents next to me. I do not have to roll over to look at the first part or the last part. I just put it in a separate documents. Then I can revise the DeFi terms at the same time. When I wrap the main provisions of the contract, I can easily refer to the other documents which contain only their DeFi terms. So technically, it could have a loss, save time, okay? All right, and more concrete, more accurate when we look at the DeFi terms whenever you refer to the DeFi terms in the main contracts, okay? Second, as much as you try to broaden or clarify the DeFi term, it should still remain what is intuitively seem to mean without close unities of the definition, which means that when you try to broaden any DeFi term, you should remember that the shortened phrase that you use at the DeFi term need to be relevant with what you define, okay? If you use the very, very broad definitions of the terms, and it's maybe difficult for people to understand when they look at the short term, even though it's already been defined, but no relevant, okay, no connection when you look at the definitions and also the explanations of the definitions, okay? All right, now avoid using words like applicable or actual or selected or operatives. They don't have the user remembers what the terms is about, okay? When defining related concept, the defined term should interact in a way that reflect the interactions of the underlying concepts that I already mentioned in the previous explanation. And one more thing, very important things that collect your definitions in one places. So therefore, in fact, I see many contracts in which people define terms two times. One is when it's firstly used, and the second one is the definitions articles. You should not do so unless a very important terms, and it could be very difficult to you know that in the defined terms, maybe the defined term did not actually, the people do not pay much attention on the defined term as to obligation of the parties. You know what I mean? For example, if in the contract, I just give you an example of the contract of mortgage. Okay, you mortgage something. So the description of the mortgage asset could be very important. And for that reason, you should not describe the mortgage asset by using or by putting it in the defined in the definition article or in the schedule that deal with definition, but you should put it separately in an article of a contract, because description of the mortgage asset is the key provisions of a contract. So in that case, you should repeat in the definition. For example, you should say in the definitions like mortgage access shall have the meaning private to it in Article 2 or Article 3 of this contract. So you need to have the whole articles or at least a sub-article to deprive the mortgage access, because that term is very important. Okay? All right, that is an exception to the advice that you should collect all definitions in one place. You still follow that advice because you also collect all of the terms would have a definition into the definition part. But if the terms that you need to define is the main obligation of the parties, or this is a key point of the contract, you need to put it in separately in a separate articles of the contract. And in the definition part, you only have to say something, and I already mentioned that, for example, mortgage access shall have the meaning as a private to it in Article 2 thereof, for example, or hereof. Okay? All right. The overall and final advice that don't get carried away. Some concepts are simple enough, basic enough, and significant well understood that you don't need a definition. Okay, so do not make them more complicated by giving so many definitions. Okay, you only give the definitions of those terms which are necessary. Okay, do not make too many terms at a defined terms. Okay, and remember that only define terms if that terms is used in your contract more than once. Okay, more than once. And please recheck to ensure that you do not define some terms that you only use once in a contract. Okay. All right, understand everyone? Okay, hi Me, you have a question? Yeah.
I have a question that if the term appears in the contract one time, but they have different meaning if we don't explain it in the contract. So should we define in the term in the introduction of the contract?
Can you give a more specific example?
Is a example like the working day. If we don't explain it in the contract, it has different meaning. It can be include the Sunday, Saturday, or not. So should we explain it in the contract by defined terms?
Yeah, it should be. It should be. But usually, for working days, actually, it have a very general meaning that everyone could understand it. But with respect to banking industries, etc., because working days can be understood differently from different industries. Because, for example, for banks, etc., some banks operate in a Saturday morning. Some banks do not operate on a Saturday morning, etc. Yes, you should define. Yes, that is a good question. Yeah, it can be. Yeah, if the term can be understood differently, and then you should define it. Yep.
Yeah, because I see in different contract, in like some contract about transportation or the seaport, like they can include the Sunday and it can count. Right.
Understand. Yep, good. But usually, for the example that you have just mentioned, working days, for example, or business days, for example, usually it will be used more than once in every contracts, usually. Okay. All right. Okay, thank you. I think that we should have a break. Okay, and after the break, we'll continue look at the glossary, which means the part that give you some understanding of the terms which are used very frequently in contracts. usually in contracts that were wrapped based on common law, from common law system. Okay, we will look at that. Actually, I should introduce that to you at the beginning, because sometimes I refer to the terms that you may not understand appropriately or correctly, because those terms are actually legal terms or legal terminologies that need to be understood in different ways, differ from the ways that the term can be used in normal everyday language. Okay, everyone, just have a break. Okay, thank you. Here, in order to understand certain term, because next part I will explain to you about the law governing contracts. In the previous section, one of you told me that what you expect in participating in this course is that to understand and can apply foreign law. Yeah, to the extent that you apply foreign law or understand foreign law, we can not understand a particular legal system or particular law of a particular countries, but you can understand many concepts that are used very frequently and you actually universally especially in common law country system. So you can understand how the term, the meaning of the terms, and also when you look at the contracts would have those terms, you could understand what the terms about. Okay, the meaning of the terms, etc. Okay, so now we look at certain terms. You look at the slide. You see the slide already or not yet? No, right? I haven't said the screens yet. Okay. Okay. So as you can see from the screens, the first terms that usually or frequently referred to is ADR. It's very popular terms. Okay, ADR means alternative dispute resolution. So traditionally, you think that every dispute can only be resolved by court. Okay, but nowadays, especially for disputes arising from or in relation to contracts, is actually be resolved outside of the courtroom more frequently. It is resolved. They are resolved outside of the courtroom. Okay, so when we refer to ADR or alternative dispute resolution, it covers other methods of dispute resolution or other forums for resolving disputes outside of the court. When you submit the case to the court, it's called litigation. But when you actually submit the case to, when you use other alternative dispute resolution to resolve their conflicts, to resolve your conflicts or disputes arising from contracts or in connection with contracts, we call it ADR. This can be a negotiation process. Usually every contract dispute, almost every contract dispute will be firstly resolved by negotiation. So you can see a lot of dispute settlement forum provisions in the contract. They usually say any and all disputes arising from or in connection with this contract will be firstly amicably resolved by the parties. Okay, right. So if the parties cannot, or if the dispute cannot be resolved through the negotiation between the managements of the parties within 30 days, for example, and then such disputes will be settled by blah, blah, blah. So usually negotiation will be the first methods of dispute resolution, especially for contract dispute. I see that Mi raised her hand, right? Mi, you want to ask the questions?
Yes, I want to ask that if the dispute clause they have the negotiation time. So after that, if they have dispute between the parties, they can keep this step and go into the court or go into the arbitration uh, mm, directly. Can it be?
No.
No?
If you already provided in the contracts, you need to go through that process. If you say in the contract, like any disputes arising from or in connection with this contract will be firstly resolved amicably by the parties, would mean that negotiation. And you usually in the contract, you say, for example, if such a dispute cannot be resolved amicably by the parties, by the management of the parties within 30 days, and then the party can submit the case to blah, blah, blah. So if you already say so in the contract and you need to go through that process. Yeah.
Okay, I see. Thank you.
Yeah, but if you do not say so in the contract and then you can skip that.
I see.
Yeah.
Thank you.
Yeah, and with respect to ADR, remember the relationship between the three methods of dispute resolution: ADR, dispute resolution, negotiation, mediation, and arbitration. It will go together. Okay, it will go together. It can go together. For example, the first step is negotiation, the second step is mediation, and the third one is arbitration. It can go step by step. Negotiations mean the process in which the parties themselves negotiate with each other about how to resolve the problem, how to resolve the conflict. With respect to mediation, usually for mediation, the parties will agree to choose a third neutral parties, okay, to help the party to settle the disputes. But for mediation, the mediator, the third party mediator, will not decide on how the disputes or conflict can be resolved, but the mediator just actually facilitates or help the party to reach the agreement themselves. Okay, so that is the process of getting to yes, which means that the two parties will agree with each other. Okay, we agree with each other in mediation process, and the mediator just help the party to reach the conclusion themselves. Okay, so that is the differences between negotiation and mediation. Negotiations mean the party themselves will settle the disputes by negotiation between among the parties, whereas mediation involves a third party, impartial third party, who will help the party to reach the conclusion, to reach the resolution themselves. The mediator will not make a decision to settle the case. Me also have a question, right? Me?
Yes, I have another question that I wonder who can be mediator. That the both party agree to the third party to be mediator, or they have the mediator have to be
Okay, I understand.
You understand my idea?
Yeah, I understand. Mediator is chosen by the parties. Okay, mediator can be anyone. But if you want to set up a mediation center, okay, and then you need to be qualified according to the law of particular countries. For example, in Vietnam, we have a commercial mediation rules. And for commercial mediation rules, they say if you are an ad hoc mediator, you do not have to fulfill any obligation, etc. But if you want to form a center, mediation center, and you need to qualify. And also arbitration centers usually actually also play a function of the mediation as well. Okay. This can be ad hoc or organizational mediation. Ad hoc mediation means that anyone, if the parties trust in that person, okay, and the parties can agree with each other that they will choose that particular person, usually the experts in the fields, okay, to resolve, to help them to resolve the problem. But if they want to go with the organizational arbitration and mediation, and they need to go for any, arbitration on mediation center, or arbitration center can at the same time plays the function of a mediation will place the functions of mediations as well.
So both parties to have to choose the mediator, if the ad hoc mediator or also the center,
Yeah.
do they have to choose before sign the contract or they can choose after the contract?
No, it's up to them. They can choose whatsoever they want. When they want, it's okay. It's up to the party. Mediations is up to the parties. Agreement. Okay?
Yeah. So it's the difference between the mediation and arbitration, right?
Yeah. Arbitration, and also arbitration can be chosen after you enter into the contract and when the dispute arrives. You can agree with the other by enter into a arbitral agreement to choose arbitration to resolve your conflict. But the difficulties in reality is that after you have a dispute, you may not agree with each other about anything if you already dispute. Okay, so usually the parties should agree on the methods of dispute resolution before when the contract is entered into. But the law doesn't prevent you to have an agreement after the contract's already been entered into, or even when the dispute arrives.
Okay, if I don't appoint, both parties don't appoint the arbitration center when in the contract, so after the contract, if one part they have disputes, so one party can go to the arbitration, any arbitration center
No.
pursue it?
No. For arbitration, it is a must that the two parties have agreed on arbitration.
So if I sue in the arbitration and other party they don't agree, they can refuse.
Yeah. Arbitration will not accept your case. Arbitration will only accept your case if you can submit to them an arbitral agreement by the two parties.
Okay, I see.
Yeah. Otherwise, arbitration will not accept to settle the case, because arbitration can only be carried out upon the agreement of the parties. At least if the parties do not have a specific agreement on which arbitral center to settle the dispute, they need to have agreed that they will settle their dispute by arbitration. Okay?
Okay, thank you.
And remember that with respect to the relationship between different types of ADR and the court and the litigation, okay? Remember that negotiation and mediation can take place every time, okay? And the parties can agree on that, okay? And even the parties already have agreed on the resolution, but they then later on do not want to perform it, okay? They can actually submit a case against to either arbitration or the court for settlement. Except for the case of commercial mediation under Vietnamese law, we have a Decree 22 that provides some provisions or some regulations on mediation. And if the two parties already reached an agreement with the facilitations of the mediator, and then the parties agree to register that final agreement of the parties to the court, and then that could be binding on the parties. But otherwise, if the parties agree on something and later on they want to change it, they can change it. They can take the case to arbitration or the court to resolve again. Okay, but if you already have a valid arbitration agreement, arbitral agreement, and that falls under the jurisdiction of arbitration, and then arbitrator already make a decision with equal arbitral award, and arbitral award will be recognized by the court and will be enforced by the enforcement agency, judgment enforcement agency, exactly similar to the situation when the enforcement agency enforced the court judgment. So it means that arbitral award will have a same effect as a court judgment. And if arbitration already have a jurisdiction to handle the dispute, the court will not have a jurisdiction to handle the case. Okay?
Like, yeah, I see like arbitral award is final and binding to both parties. But how about mediation award? Is it binding?
No, according to the new decrees on mediation, it can be binding if it is registered.
Oh,
Yeah.
so both parties agree and register in
Yeah.
the center.
Yeah, register the agreement of the part. Okay, with the head of the arbitration.
I see. Thank you.
Okay. Yep. All right. So the next terms is assignment. These terms will also be used very frequently. Okay. This is a transfer of rights or duty by the assigner to the assignee. This may occur only by agreement or by operation of law. For example, when someone dies or when a party is bankrupt, that is the assignment by operation of law. So when you see the term by operation of law, it means that by law, it means that as provided for by law. So you can use the term by operations of law. Okay, that is a synonym to as provided for by law, okay, or under the law, okay, so it's equal by operations of law. Okay, so assignment can happen in two ways. One way is that the parties to a contract agree with each other to assign their rights and obligation to other parties, okay, or the assignment takes place when one party dies and the successor of that party may agree to take over that the obligation and rights of the parties who already died, okay, or when the company is bankrupt or insolvent and the other company may buy that company, and the company that buy the company may inherit the contractual obligation of the company which already been bankrupt. Okay, so that's equal assignment.
Play teacher.
Yep.
I have a question.
Right.
May I have assignment mean when someone die or when a company is bankrupt. But previously I have thinking that the assignment mean transfer mean party A transfer to party B for the contract or the grant obligation, any grant obligation. May I understand is correct or not?
Yeah, there are two ways that I already mentioned. One way is that it is a transfer of assignment based on agreement of the parties. Okay.
Yes.
Yeah, and the other one is when the law apply. Okay.
Yes.
Yeah.
Okay. Thank you, teacher.
Yeah. All right. And the next terms that you frequently in contract law is the battle of the forms. So what battle of the forms mean? It is a common business situation where business parties establish their relationship by sending a standardized form to each other. Often, the terms of the form do not agree, and it can be difficult to tell if the parties have concluded the contract, and if so, what the terms of that contract are. So this is the situation, for example, I send the offer, okay, my company send the offer to sell my company goods to company B. But that is my form, my company form. In the form, I say something like, I offer to sell you this amount of goods, the qualities of the goods is, the quantities is, and also certain term and condition I put in my offer to send to company B. And company B agree to buy the goods, but they do not sign on my form. they do not say I accept. They do not. They did not sign in agreement in the form that I sent to them, but they then send back their own form. Okay, and in their own form, they say, okay, we agree to buy certain types of goods, qualities like that, quantities like this, and they put some more legal terms into their form. They use their own form, okay? And even though they say, I agree to buy, but in their form, there are different terms and conditions. And in such a situation, legal questions could arise as to whether that is an acceptance or not. Or is this a counter offer, new offer, made by the offeree, original offeree? And if that is the case, the original offeree will become the new offerer, for example. So that equal the situation will be called the battles of the forms. And in such a situation, it needs the determination by the dispute settlement mechanism if the parties submit the dispute to the court or to other dispute settlement forum. Okay? Understand?
Teacher, can I have a question?
Sure.
I did look into the bottom of the forms, and sometimes when the court want to conclude whether whether the party already enter into the contract, they look into the principle of offer and acceptance in the bottom of the form. If the question is the offer and acceptance is actually matter in real life, or actually in the context of the bottom of the forms, or in the context of real life in real life practice? So I think
Yeah. It's happened in practice. The question of whether the offeree already accept or have not accept the offer.
Yes, because in the principle of offer and acceptance, when a party A send a form, it could be understood as an offer.
Yep.
And then the other side, and then the party, when they send back the form, but they did not use their own standard form, and then this could and somehow there's some variance, there's some differences in the form. Maybe it be similar in the essence, in essence, like some commercial terms, like it's all similar, but there is some changes in maybe some choice of law some choice of law provisions, or some kind of provisions that the party doesn't care that much. So actually when I look into contract law, the offer and acceptance principle in Vietnamese law, they quite neglected. So I think so I want to ask a question about is relativity in real life, how it actually applied in real life practice, or some kind of thing like that.
In fact, the line is not good, so I didn't hear very clearly. Can you make the question clear? What is your questions? Can you summarize the questions? What is the key question? I didn't hear clearly because the line is not good. So what is your question?
So in the context of negotiations and the battle of the forms, the parties in real life actually care about that much about the offer and acceptance?
Yes, of course, because there may be some inconsistent, maybe some dispute arise later on. Maybe the party may say, for example, if I offer to sell by sending a piece of paper, okay, using my form, and then the other side actually send back using their form saying that I agree, but they then revise some term, they put some more term, and then I didn't deliver the goods because the price now go up already. And then in that case, the original offeree say, okay, I agree already. Why you didn't deliver the goods? And they may raise disputes. And in that situation, the court will look at the two forms in order to determine who is right and who is wrong. It happens very frequently, very often. Understand?
Yes.
Yeah,
because
when the market
because,
condition change.
Yes, because I'm writing a publication on offer acceptance and some problems surrounding battle of the forms and the contract as a whole. And so I did some research on the Vietnamese courts, but I couldn't find any decisions or find any cases related that related to the offer and acceptance in real life. So that's the reason why I'm asking you this question, because
Yeah, very frequently. I have involved in many cases when people dispute about that, especially when they want to, not necessarily when they firstly establish the contract, but when they amend the contract that they already enter into, and the same rules will apply. For example, if we already have a contract with each other, we agree to buy and sell certain types of goods, and then during the performances of the contract, maybe Party A send a letter to Party B, amend some provisions of the contract. Party B may send back the letter saying something else, okay? And they may dispute on whether the parties have already been agreed on such amendment or not. This is apply also the rules of offer and acceptance in order to come to the conclusion on whether the amendment had been made. It happened very frequently, in fact.
yeah, thank you so much.
Yeah. Okay. In reality, when the parties perform the contract.
Now I can confidently write my publication. Thank you so much.
All right. Okay. Yeah. Because it's not really for the first time when you establish the contract, but when you want to amend it as well. Okay. The rules of offer and acceptance will also apply. Okay. And the next terms that you need to pay attention to is the term boilerplate. What does it mean? Boilerplate clause usually mean the term would have the legal aspect, and they put it in the contract for to avoid some conflicts which may arising out from the contract performance. For example, when one party actually argue about the language used in the contract, that is about the language of the contract, whether it is in English and it is executed in English and Vietnamese, but with language prevail, for example, it could be put in a boilerplate clauses. So boilerplates mean the clause which are used to settle general matters such as choice of law, notice procedures, amendment procedures, interpretation issues, dispute resolution mechanism, etc. And they have forms for those clauses. And you can use the forms. Of course, you may revise it, but they have forms. Okay, they can use it. They do not have to create the new terms because they happen very frequently, and legal researchers and also legal practitioners put them into some kinds of moral contracts, okay, right? So you can simply copy them, but you need to understand them. And of course, the party can negotiate in order to amend the boilerplate. It not necessarily means that the parties have to agree to any standard form. The party can always revise it, but those terms, boilerplate, that are those terms which are used very frequently in the contract, and they usually have forms already. Okay, so that's called boilerplate clause. Choice of law clause. Actually, you are allowed to choose the law applicable to contracts in a limited circumstances, which means that not in every case you can choose the applicable law. Okay, usually choice of law clause used in the contracts that the parties to the contract come from different countries. Okay, so that you call contract with foreign elements, and you can choose the law applicable to contracts. And sometimes within countries, you can refer to apply this law other than the other if the law allow you to choose. For example, if you are an individual, you enter into the contract with a company, okay? If you do not choose commercial law to apply to your contracts, and then the civil code will apply. But if you want certain specific provision of the commercial law to apply to your contracts, and then you can put it at a choice of law clause in your contracts in order to choose commercial law at the first applicable law to contracts. And you know that in Vietnam, the relationship between commercial law and the civil code is that the civil code is based and the commercial law provide provisions specifically applicable to commercial contracts. However, if, and in many cases, the commercial law does not provide specific provision on some general terms, and then you need to refer to the civil code for those general terms. For example, for contracts, the rule relating to offer and acceptance, when the contract is formed, when the contract takes effect, etc., are governed by civil code, not by the commercial law. So if you enter into the commercial contract, but the commercial law doesn't have specific provision dealing with specific situation, and then you may need to look at the civil code for specific provisions. Okay, so once again, I just want to emphasize that choice of law clause actually more frequently used in international contract rather than domestic contract. Okay, understand about choice of law? You can also choose the dispute resolution mechanism. So usually in a choice of law clause, they will say governing law and dispute resolution settlement. Dispute settlement. Okay?
Yeah, can I have questions?
Yeah, sure.
That, like, because when I review the contract, I see a lot of contract, they choose the law is England law, but actually I don't know so much about England law. So how can I can I exchange the law, or you can have advice for me to choose another law?
Yeah, I understand. But in that case, it's depend totally on the parties' agreement. Okay, it depends totally on the parties' agreement. That is rather a commercial decision, even though it relating to law, but it is a commercial decision of the parties, because the law allow the party to choose which is the applicable law, right? So that based on the bargaining position of the parties, But I just want to note that I don't think that in every cases you should use Vietnamese law. No. Okay. The reason is that because it doesn't mean that Vietnamese law better than English law. You want to use Vietnamese law simply because you understand Vietnamese law. Okay? Right? Not because Vietnamese law is better than English law or Vietnamese law better protect you than English law.
Mhm.
So
Yeah.
for that reason, do not have to actually fight for Vietnamese law to apply. But what you need to do is that you need to seek advice, okay, from if that is important legal document, important contract, you need to seek advice from English lawyers, okay, to see whether English law in that situation could protect your rights, okay.
Yes, I see. Like,
Yeah.
but how about because like some it's follow the model contract and the GATTA, so the GATTA to the England law. Right? So if we are not between Vietnamese company and another company like India or a Chinese or other one, so can we choose like the third country laws like
Sure.
yes.
Sure, you can. You
Mhm.
can, but subject to other parties' agreement as well. You can't decide it by
Mhm.
yourself. Yeah. And I think that it's better to choose the law of the country, the developed law rather than less developed one.
Yes, and I consider that the CISG should apply to the contract, international contract.
Yeah, sure, you can do that. You can do that,
Mhm.
yes. Yeah, the
Mhm.
CISG could apply automatically if the parties to the contract come from the country with other party to CISG. Okay, it's become applicable law automatically unless the parties to agreement decide to choose the other country law. So in that situation, you may persuade the other parties that okay, we come from the countries that parties to Vienna Conventions on the sale of goods, international sale of goods. So we should apply that law because this is actually the results of the compromise between the countries already. So it's suitable for international contracts. So we should apply it or something like that. But if you have a transaction with party that come from England, it's very difficult for you to persuade them to apply law other than their own law, because you know that the English people, they very confident that their legal system, their law is the best, the most comprehensive one, okay? So they will persuade you to apply that English law, yeah. In most of the case, yeah. And if you apply English law, it is about common law. Okay, it is about common law, especially for contract. However, England have a very famous piece of legislation that govern contract, self-good contract, that is Self-Good Act 1979. It's a very famous one, and it's a very, I mean, the term and conditions are very universally accepted. And Vietnamese law, the commercial laws of Vietnam, is actually have many provisions that follows the rules provided for in that self-good contracts, self-good acts of the UK. And you know that UKs were very developed countries a long time ago, and legal system was developed long time ago and being a model for many country law. You don't have to worry too much about the applicable law could be English law. You can see that England have some piece of legislation which was adopted very long time ago, but still applicable, which means still effective. For example, the Bill of Exchange Acts. The Bill of Exchange Act were adopted in England in 1855. Can you imagine? In 1855, they adopted the Bill of Exchange Act, and it's now still applicable. So they developed the legal system very early. And for the main key principle with governing the corporate governance, you can see that in the UK, they have a choice stock company act back to the year 1944 or something, but it's still applicable. And then it's now is the contract law 2006, company law 2006, and the company law 2006 in the UK is actually codify all of the common law principles that govern the corporate governance and also relationship of the shareholders in the company. Many provisions of that act universally apply, and it's already been developed for a long time. So I think that it's good law. This is a good law. Don't have to worry too much. If the law of those countries apply, English law apply, it's universal accepted. Many principles universal accepted. But the difficulties for you is that you don't know about English law, so you are faced of applying the law that you are not familiar with. But if you know that the laws are very comprehensive and it is very commercial based regulations or law, you don't have to worry too much.
Okay, thank you.
Yeah. All right. Any other question that you may have? Okay, if you do not have any questions for now, and then we can stop, right? Okay, we can stop here for now. Thank you, everyone.
Thank you, teacher.
Okay, bye-bye.